May it please you, my lords, I appear in this matter for the appellant, Brian Richard Bowser, who is a former executor of the will of Ian John Smith, deceased.
Yes.
My friend Mr. Hicks appears for the first respondent, Mrs. Julianne Smith, who was also named as an executor in the will. Both of them have been replaced by order of the court by Mr. Green as administrator, and he appears in person as solicitor advocate for the second respondent.
Yes.
My lords, can I just do some very quick housekeeping, just to make sure we've all got the correct bundles? The court should have two appeal bundles, a core bundle and a supplemental bundle.
Yes.
An applications bundle was filed yesterday, and that contains the documentation in relation to the application to join the second respondent and the order joining her by this court, Lord Justice Moses' order.
Yes, that's the one. This one, I think.
And that's got that application. It's also got the my friend's Mr. Hicks's application for permission to reduce evidence at this hearing, which I'll come to very shortly, and the skeleton arguments in support of that. Does the court also have the combined authorities bundle, which Mr. Hicks and I were able to agree? That has
yes, a formidable number of cases for a costs appeal.
But I hope can be dealt with very, very succinctly.
It also, at least in my copy, doesn't have any sidelining, which makes finding the relevant bits of considerable pain.
I will endeavour to make sure that it's easy for the court to follow where the authorities are. In the case of my authorities, almost invariably the key passages are in any case identified in the skeleton argument. And I hope that can be dealt with fairly quickly.
Yeah.
I see that the applications bundle from the index has a skeleton argument from you in response to the application, although I don't think, well, I certainly had not seen that before, and I'm not sure that
I filed that myself before this was done.
Right.
So I think that was yesterday morning when they were exchanged.
All right. Anyway, you ought to be aware when you make your submissions that we haven't seen that.
I'm grateful. And that bundle also should include the version I have doesn't have the note from the second respondent. He's put in a note instead of a skeleton argument in view of his late joinder, and that should also be in the bundle.
Well, is it? I certainly haven't seen that.
A7 in the
A7. Oh, thank you.
Oh, yes.
Oh.
Oh, it is. My friend has assisted me. It is there. It's at section A7 in the applications bundle. That's the administrator's note, and I understand he has one or two additional documents that he may wish to hand up to assist the court in understanding the current nature and value of the net estate.
I see. Thank you.
Yes.
My lords, I do also, going through the hard copy bundles, I discovered two missing pages, which I have done. There's reference to my draft orders below, but they are not in the bundle, and I have copies of those. And I also have a missing page from my skeleton argument, which was also, I'm very sorry, missing from the electronic bundle. And with the court's permission, I would hand those up. I have put page numbers in the bottom.
Yes, thank you.
Also, certainly in my hard copy bundle, the statement of the respondent, Julie Smith, is cropped at the top and bottom of some of the pages.
A full copy has been requested. That was before the application for Mrs. Justice Bacon, but is not available.
I see.
And my understanding is that Miss Smith had assistance with preparing it, but dealt with most of it herself, and must have photocopied it in a way that meant that some parts were missing. Anyway, that copy is the best and only copy that's been available to any court.
I mean, one can guess what the missing lines probably say.
Yes,
Not a
and
major point,
the
but
substance is clear, and we have perhaps moved a little bit beyond
Thank you very much.
the factual matters in any event.
So just tell us where you want this to go in. The claimant's draft cost order goes in the main bundle.
Yes, that goes into B. The claimant draft order goes in at B106A. If you look in the bottom right-hand corner, my lord, I've put in manuscript. I've put a page number there, and that goes in behind the cost submissions that I made on paper to Mrs. Justice Bacon
Oh, in the supplementary bundle.
in the supplemental bundle.
Okay.
And the pages missing from my skeleton argument in support of the main appeal, that goes into the core bundle after A32, and I've numbered it A32A.
It is there in my copy.
It isn't there in mine.
I'm afraid I can't read the numbers in the bottom right-hand corner. They're all smudged. Wrong bundle.
Core bundle.
Yes, it's all right. I've got it in.
yes, I've got it. I've got it anyway.
All right.
I'm sorry, I haven't. I haven't got that.
All right. Well, the good news is we have read your skeleton in its complete form.
I'm very grateful. My lord, I believe Mr. Green has some documents he wishes to hand up in respect of the value of the estate, having recently received an updated valuation.
All right. Well, we'll get those first, shall we?
Yes, thank you. My lords, my lady, it's only 3 pages. The report from Maxi Grounds on the land in the estate arrived after 5 p.m. yesterday, so this is hot off the press. There are 3 pages. I'm in your lords and ladies' hand as to where you wish to put that. The material effect on the estate is to add £86,000 onto the figures I provided in the note. That's the top and bottom of it.
Right. Well, perhaps we might put that after your note then.
Thank you.
Thank you very much.
Thank you.
My lords, I'm very much lady, I'm very much in the court's hands. I would anticipate that you'd want to hear first Mr. Hicks's application to adduce further evidence.
Yes, we could do that first.
And then, if that matter's got out of the way, then proceed with the main appeal, including or not including that evidence as the court sees fit.
Yes, very well.
Well, I'm happy to proceed in that way, my lord. Although it may make equal sense to hear the whole lot together, but I'm happy that it's not a difficulty, because the two obviously interlink so closely, and the relevance in particular of the additional information is key to the and must be seen in the general context of the appeal and the costs order made. But I'm happy to deal with it like that. Taking a step back, the way we see this case is that it was flawed procedurally, legally, and commercially at all stages, such that it was entirely proper for Mrs. Justice Bacon to make the order that she did, and certainly not manifestly unjust to do so, which, as I will come on, that is the test in a case of this particular nature, where the costs are made further to a consent order. But I think there's a core of the, taking a step back, a core understanding of the context of this case is fundamental. My client, I'm going to refer to her as Julie, which I hope is no disrespect, just makes things a little easier. Julie is the mother of the beneficiaries.
Well, she's not content with that. Then that's
she's
fine.
not here, unfortunately. She's, as I was going to go on, she has 10 children, 9 of whom are living with her, 8 of whom are minors, the youngest being 4 years old. So I'm afraid she is at home as a single
If she's
mum.
content for us to refer to her in that way in our judgment, then that will make life easier.
May make things easier than referring to Mr. Smiths and Mrs. Smiths. And under the terms of the will, she is appointed co-executor with a solicitor from Bowser's, not necessarily Mr. Bowser. And the estate is divided 10 ways between the children. And that was made following separation and prior to, so when a divorce was anticipated, but prior to that being resolved, of course, Ian Smith died. Litigation is obviously expensive, so for a personal representative in this case to pursue any claim is at risk of very serious costs being incurred either by the estate or Julie or both. And every pound that is incurred by Julie is equally prejudicial to the interests of at least the 9 beneficiaries living with her, because they are dependent on her. She's their mum. So for the PR to pursue any litigation, the risk is of inherent prejudice. The costs are inherently prejudicial irrespective of where they land between the estate or Julie. And so it's even more important that any claim in this case was well-founded, seriously needed to be pursued, was sound both legally and, importantly, commercially, that the benefit was actually worth the ultimate result. And contentious litigation, we say, could and should have been avoided in this case, and ultimately that was curtailed for the blindingly obvious reason that if there was any litigation about the appointment of the PRs, which was almost inevitably going to incur significant costs, there was always a way out, which was that everybody backs down, an independent is brought in at minimal cost, by consent, that everyone goes on their way, and the estate is administered in that way. And that's ultimately what happened, but only after we had a hostile claim brought and significant costs incurred. And so ultimately there is a serious question in this case as to why on earth it was ever in the interests of anybody to jeopardise the interest of the beneficiaries by engaging in expensive litigation when there was that way out. It would, even if the claim had succeeded, it was going to be to the significant financial detriment of this family. And it's in that context that that one must look at what happened. We say the procedure that was followed was flawed. The case was legally flawed.
All this sounds as if it's your response on the merits of the appeal.
I think but it's important to understand how this links into the Ladder Marshall application, because the Ladder Marshall application, I can turn straight to the core of the Ladder Marshall application. It's my skeleton. I hope you have my skeleton argument. And
sorry, and I don't want to cut you short. I mean,
no, I'm very happy to.
Your basic point, surely, at least I think it is, as articulated in your skeleton, is that this new material underscores and reinforces the approach which the judge took.
Absolutely, because it now turns, because I think it's the commercial context of this case is important.
Well, the point that emerges is that Mr. Boucher had a glaring conflict of interest on his own part.
Absolutely.
Which had not been made clear to anybody, let alone to the court.
Absolutely.
When Mrs. Justice Bacon heard the heard the the application on the 3rd of November last year.
Absolutely. That's exactly it.
So he was on any view in a position of conflict himself.
Yes.
He also, rightly or wrongly, took the view that Julie was in a position of conflict. But I mean, that just reinforces what you, in your skeleton or main skeleton, described as the absolutely blindingly obvious solution, which is to appoint a single independent PR.
Yes, absolutely. The point I was making is when one takes a step back and looks at the context, it underlines the procedural defects. This should have been and could have been flagged, dealt with before any proclaim was brought. It underlines the legal context problems because one is engaging in a litigation where one is seeking the removal of one PR on the basis of a conflict. And in fact, it turns out the boot may very well be, if not on the other foot, on both feet. The boot may be on both feet. So there was a serious legal problem with pursuing this. And then when one looks at the commercial risks, which I've just referred to, of course, the risk of the litigation is where's it going to end up? It may end up with Julie's removal, but there was obviously then a very serious risk of Mr. Bowser's removal if this had fought. It makes the conclusion that this should never have been engaged in and an independent PR should have been appointed even more obvious. That's the nutshell of our case.
And you say you only got this material very recently, and you put it
Yes.
before the court, you say, as promptly as you could.
Absolutely. I think we had the conveyancing file we had last Thursday, I believe. There's an email in the application file showing that coming in.
The one thing you did have last November was the TR5, albeit only a few days before
Yes.
the hearing. But I think you say, in itself, that doesn't set alarm bells ringing, or at least not
Yes.
as obviously as when it's put in context
Absolutely.
of the conveyancing file.
And we had asked for the conveyancing file. That's in the correspondence. Your Lordship, I hope, in particular, the 5th and 7th of October letters. We'd asked for it, and we'd been rebutted. Essentially, I don't think explicitly told, you cannot specifically have this file, but we were told we're not making disclosure, and we didn't get it. And the TR5 of itself, it does have Bowser's witnessing a signature, but it's no more than that. That's it. So that wasn't enough to flag a serious conflict. We didn't know anything about the transaction. But when one goes into the transaction itself, the conflict is very, very obvious and serious.
I mean, that's for the reasons you say in your...
Yes,
Yeah.
absolutely.
Yes,
I don't know.
I think we understand that,
Yes.
that point. Perhaps the best course is if we hear Ms. Taylor, and then if need be, you can come back and respond.
I'm very grateful, my lords and lady. My skeleton argument is in the applications bundle at page 181 of 224. That's the electronic number. It's page B62 in the bottom right-hand corner.
Yes.
My lords, I haven't, and lady, I haven't opened on my appeal, and I am disappointed that Mr. Hicks has, in effect, opened on his response, because the issue on the application is simply whether the additional evidence should be allowed in at this stage. And it's said to be a Ladden Marshall application, which is an application to put in factual evidence before the Court of Appeal. And I have set out in my skeleton argument just an analysis at section A that late permission is being sought. Of course, it's supported by the witness statement of the first respondent's solicitor, Ms. Stevenson, and that permission is technically permission is needed for short service if it's to be dealt with today. But it is opposed by the appellant on the facts and on procedural grounds, and that's why I say that the court should not admit this evidence at the appeal stage. What I say first of all is that although paragraph 6 of my skeleton argument, the appellant of course accepts that the Court of Appeal has a general discretion whether or not to receive fresh evidence. But I say that this isn't fresh evidence because the court below heard no evidence and there was no trial. And what I say in relation to the grounds of my appeal is that this matter probably ought to have been dealt with on evidence. I've identified before Mrs. Justice Bacon and here facts and matters that the appellant would want to put before the court, particularly if the matter of conduct is going to sound in costs. With regard to that, there is no evidence, such that in my submission it would be unjust to admit this single piece of contested evidence.
Well, wasn't there, I mean, there's no oral evidence, but wasn't there material before the court below? There must have been.
There was the witness statement from Mr. Bowser. There was the witness statement of Ms. Smith, to which the court has referred, the truncated one.
Well, that is evidence, isn't it?
But the application itself was not. It was, but the application itself was not heard.
Well, that's because you reached a settlement and you agreed on the procedure that was to be followed on costs.
Well, it's because we were adjourned before any evidence had been led, and then the issues in those witness statements were bitterly contested, and so it wasn't possible to make any findings on the evidence.
And you agreed to the procedure the judge was going to follow, even down to the number of pages for the submissions that were to be put in. And that is then precisely what happened. And you can't now complain about that procedure, which you all agreed to, having been followed to the letter.
Well, that was directed, not agreed, my lord, technically speaking.
Well, it says by consent at the beginning of the order.
Well, it was
And if you
consented.
read the transcript, it was obviously perfectly obvious what had happened.
Yes, and then what was to happen was that the matter was to be the cost submissions. It was not possible for my friend and I to make them because we hadn't come ready to deal with the costs of that entire claim. We'd come ready to deal with the costs of the application. and accordingly the matter had to go off. And I did ask that it be adjourned to a hearing, and it wasn't adjourned to a hearing. But what then happened was that without determining the issues of conduct, because they couldn't be determined, an adverse order was made, which in effect was based on misconduct. And those are matters that I've raised in my appeal.
Yes.
And so what I say is that if it is right that this matter has to be dealt with on evidence, including the contested evidence now being put in by my friend in relation to the transaction, where Mr. Bowser is very clear that he did not act for Mr. Paul Smith. The person he acted for was the testator. The scope of the retainer is a matter which hasn't been determined, and in my submission can't be determined where the parties on paper are saying something completely different from each other. Although the reasonable inference from Mr. Bowser's evidence and the evidence that isn't disputed, that the testator had his own divorce solicitors, is that this was simply an execution retainer. In that regard, the testator's conveyancer then going on to accept the appointment as the testator's executor, in my respectful submission, there isn't a conflict there. And the difficulty for him would be, how could he challenge his own transaction? The person who is in a position to challenge the transaction was the co-executor, but not in her capacity as executor. In her capacity as the wife in the financial remedy proceedings, if she thought that this was a collusive transfer, if she thought that it was a settlement of a soft loan, those are applications which are absolutely routine in financial remedy proceedings. With the death of the testator, that's a matter which would fall within the scope of her Inheritance Act proceedings. It's not clear that this is a matter that the estate would have had to investigate, and I say that where Ms. Stevenson has said that this is naturally something.
Okay, but Ms. Taylor, the conflict that's being relied on the part of Julie,
yes,
is the fact that she wants to bring a 1975 Act claim, and the material here is also relevant to that, isn't it? Because, as you say, she may wish to challenge that transaction as part of that claim.
But that puts her in a position of conflict. It doesn't affect Mr. Bowser. Once the executors have been appointed, and they obviously were acting from the will in this particular case, they stand in the shoes of the testator. And this was a transaction which the testator had freely entered into in June-July 2020. And to challenge that, therefore, they would have to challenge their own transaction. If the conflict, as I understood it, was that Mr. Bowser was said to have acted for Mr. Paul Smith, the father, on that transaction, which he did not do. And the court would have to be satisfied that he did, and in my submission, this court can't be satisfied of that unless the matter's tested.
Well, he certainly did act to the extent of getting the transactions registered.
Yes, but that was on the instructions of the debtor. So that was Mr. Ian Smith, the testator, asking him to register his father as the proprietor of those properties. And if this was a collusive transaction, if it was in settlement of a soft loan, which otherwise, but for the divorce, would not have been called in, that is not extraordinary, because the person wishing to do this would, of course, be the testator. It wouldn't necessarily be Mr. Paul Smith at all, and the Bowsers did not act for Mr. Paul Smith. Now, that I understood to be where the conflict is said to arise. It can't arise for having acted from the testator, so that the only possible way that it could arise out of that conveyancing transaction is if it said that the executor, having acted for Mr. Paul Smith before, wasn't in a position to challenge the transaction, making Paul Smith the registered proprietor of those properties. But that isn't the case. He did not act for Mr. Paul Smith, and this court cannot be satisfied that he did with respect to Mr. Hicks. That's expressly denied by Mr. Bowser in his witness statement, and he deals with his knowledge of Mr. Paul Smith, the father. He deals with that at paragraph 14, which is on page 169 of 224, B50 of the label B50 in the bottom right corner if anyone's using a hard copy.
Sorry, B15.
50, my lady.
Oh, thank you.
Of the applications bundle?
This is
Or-
applications bundle. This is the applications bundle. Electronically, it's 169 of 224.
Okay, I don't think you've seen them.
And what
I haven't seen this statement before. Perhaps we should just read it for a moment. Yes. Why was the conveyancing file provided at such a late stage?
my instructions are that it was provided on the 12th of April 2023, provided when asked for. Mr. Bowser's own evidence is that when he was asked to provide things, he did, and I have some instructions in relation to that. The instructions I have is that Mr. Green, and he may have details of this himself, asked for asked for a list of files, which was provided in the letter of 28th of February, and that was received because it was referred to by Mr. Green in his following letter. It's difficult for me to put this before the court because it isn't in Mr. Bowser's witness statement. But if the court is willing to accept this on instructions, yes, but not.
Yes,
Yes,
that's the one.
yes, but it's not the material that I'm dealing with.
That's it.
No, it isn't. That's not what I'm dealing with. The issue from the perspective of Bowser's was that although Mr. Green asked for specific files, he was asking for specific items as and when he wanted them. So that is the reason why they did not get a request asking for all the files, and those are the instructions that I have. I'm afraid that isn't in Mr. Bowser's witness statement.
I thought Mrs. Justice Bacon, again, as part of the agreed order, made a direction, didn't she, that all files are to be handed over within 7 days. So there was no need for a request. It was just a court, I say just, there was a court order which had to be complied with.
My
Or
lord,
have I got that wrong?
My lord, my lady, I can't assist further on that matter. I do have Mr. Fellows in court with me, but I don't know. Might I turn my back for a moment? My lords and lady, I'm not able to assist any further than that. Mr. Fellows doesn't have any further information either as to why that order was not complied with.
Right. Anyway, you wanted to take us something in the witness statement.
Yes. Have your lordship, has the court read the witness statement or just the passage that I was referring to? The passage I was referring to is at paragraph 14, where Mr. Bowser deals with his conduct of the testator's conveyancing retainer. As I say, in the actions of the testator could not have created a conflict with him accepting office of executor. And he deals with Mr. Paul Smith, and as I understood it from Mr. Hicks, this was and Miss Stevenson's witness statement, this is where the conflict is said to lie, that he's said to have acted for Mr. Paul Smith, and he's very clear that he didn't. And he deals with the extent to which he knows Mr. Paul Smith, and he is not in any sort of legal knowledge of him. He also says at paragraph 16 that the retainer was not an advice retainer, simply an execution retainer, and that to the extent that Miss Stevenson says that Mr. Smith, the testator, should have been advised in relation to the implications of transferring property whilst in the midst of financial remedy proceedings, that was clearly a matter for his divorce solicitors. And Mr. Bowser was not aware of those proceedings, and I still to this date do not have the divorce file. It's quite clear from Mrs. Julie Smith's witness statement that there were proceedings in relation to contact, there were proceedings in relation to ancillary relief, financial remedy, and others. But Mr. Bowser was not concerned with those.
But can we just go back to Mr. Bowser's position as personal representative?
Indeed.
I mean, if as he wanted, or if as he argued, Julie should step down, that would have left him as sole personal representative.
Yes.
And one of the first things he would have had to do was to sort out the inland revenue account, what assets are in the estate.
Indeed.
And for that purpose, he would need to form a view, wouldn't he, about what happened back in 2020 when these two properties were sold, ostensibly, but not in reality, for a consideration of £85,000.
Well,
And immediately paid consideration of £85,000.
he-
I mean, was this a lifetime transfer value or wasn't it?
Well, he
That's the
did-
question he would have had to get to the bottom of.
Indeed. And
How
he
could he do that when he had acted himself in that very transaction?
Well, he deals with that, my lord, at paragraph 17 of his witness statement. And he says, if there was evidence of a transaction at an undervalue or some other irregularity in any transaction within the period of 7 years
Yes.
before death, then the executors or those advising would need specific details to enable the executors to complete the relevant capital taxes office forms. And if I could take you back to page 165, which is his file note, and this is exhibited to Ms. Stevenson's witness statement, this is his file note of what he understood his instructions
Sorry,
to
what
be.
is the...
Page 165 of what?
Sorry, of the applications bundle.
Yes, but we're not
Yeah.
working electronically, so can
Oh,
you
I'm
give
sorry.
us the...
Oh, I'm so sorry. I
A
didn't
or
appreciate
B?
that. It's B46 in the bottom right-hand corner.
Thank you.
Yeah, thank you.
And he says, his evidence says that this is his file note.
Yes.
He's attending Ian Smith, this was on the 24th of June 2020. It took about a month for the transaction to go through. There is a transfer, the properties are identified, the transferee is identified, Paul Anthony Smith. I'm sent to MO, which I would anticipate in the March office, for execution. This is to repay an old debt owed to Mr. Smith Senior, amount of debt to follow, split 50-50 between the two properties, 45,000 recently, 40,000 from years ago, 85,000, 42,500 for each. Now that is what he knew, and in those circumstances, it can't be said that he knew that it was a transaction at an undervalue, or that it was a collusive transaction, or that the loans were soft loans.
No, but wearing his hat as PR, he had
Yes.
obviously would have had to investigate. So how is he going to investigate something which he'd been material in personally facilitating
Well,
on behalf of the deceased, or assuming you're
Yes.
right, he was acting only for the deceased and not for
yes,
the
he was only
transferee.
acting for the deceased, and therefore he would know that he had transferred properties of the deceased.
Yes, but in working out what the effect was on the deceased's estate,
Yes.
surely he would have had to get to the bottom of what was going on, wouldn't he? Or...
Well, it depends, as he says in his paragraph 17. It depends whether it's inherently suspicious.
Well, of course it's inherently suspicious. I mean, it's absolutely glaringly suspicious. I mean, it may be satisfactory answers can be provided.
Indeed.
On the face of it, it looks like a pretty blatant attempt to get round the ancillary relief application, which was, if not then on foot, obviously going to happen before very long.
And it's obvious from the file note that he didn't know very much about the loan. He doesn't even know
Indeed.
what the amount of the loan
No,
is.
he-
So there's quite a lot to investigate.
Yeah, and
He
he
certainly asked no questions then, but he might have had to ask them later.
he didn't, but that depends very much, I would submit, on the scope of the retainer. I'm very sorry that I did refer to Minkin and Landsberg in my skeleton argument and have forgotten to put it in my bundle of authorities. But it would depend on the scope of the retainer.
Yeah,
But even if the retainer at the time was
Yes.
execution only,
Yes,
when it comes to acting as a PR, you've got a duty to find out what has happened in the 7
Indeed.
years before death,
Indeed.
probably.
yes.
And that requires a duty to be able to file the forms with HMRC. Don't
Yes.
you need to have made some inquiries?
Yes, but of course he had limited knowledge from the point of view of the execution retainer. Whereas and in relation to the value, I hear what the court says about it being inherently suspicious, but that would depend very much on, for example, the mortgages applying to those properties, and the court will be aware that if that was the net equity in those properties. If Mr. Paul Smith, for example, was taking those properties subject to those mortgages, then it could well be
wouldn't
that
that be
the value
apparent?
itself was
That
not suspicious.
Whether there were mortgages or not would presumably be apparent in the process of transfer, because they would have to be dealt with.
Yeah.
There would be stamp duty to pay if the mortgages were assumed, so I'm not sure there's any indication that there were mortgages.
Well, I hear what the court says, but in relation to that, what Mr. Bowser says at his paragraph 18 is that it's clear that the transaction would have been relevant to those matrimonial proceedings, but of course Mr. Bowser was not concerned with those, and Mrs. Barr Ellison were the deceased solicitors in relation to that, and it might also be relevant to her current claim, but she does not explain, he says, how those transactions affected either of Mr. Bowser or Ms. Smith in their office of personal representative. So that's the evidence that he has put in. He also explains at paragraph 19 that because of the early stage at which the removal application was made, he was unable to complete any investigation into the testator's business affairs, including transactions such as transfers of property in the 7 years before death. Although the transaction may have been at an undervalue, that wouldn't have been something. Let me go. The testator freely entered into this transaction. The transaction emanated from him. It was not suggested, for example, by the solicitor or anything of that nature. And it's a matter for him what he does with his property. It's also a matter for him whether he leaves his affairs in such a state that after his death there are going to be claims against his estate challenging such transactions. But that is not a matter for him. If this had arisen in the financial remedy case, it is possible that Ms. Smith would have been given permission to require evidence to be filed by the testator and possibly by Mr. Paul Smith, and it is possible that some kind of obligation would have been imposed upon Mr. Paul Smith to bring those properties back into the matrimonial pot. In my respectful submission, the estate standing in the shoes of the testator would simply stand by its own transaction. it isn't as if the transaction was entered into under compulsion, or if it was, that was known to Mr. Bowser.
But it was known that Julie was going to bring a 1975 Act claim.
Indeed.
Which is, as one would obviously expect in a tragic situation such as the one that
Indeed.
transpired in this unfortunate case.
Indeed.
And on that basis, is it Section 10 of the 1975 Act which
yes,
enables...
the anti-avoidance provision.
The anti-avoidance provision.
Yes.
Well, that exactly is likely to be bang in point, isn't it?
Yes, but in that situation, Mr. Bowser as personal representative, or indeed Mr. Green now, would be adopting a neutral position. So the person making the claim would challenge the transaction. The estate would be neutral. And the live defendants would deal with whether the transaction was liable to be set aside.
Well, that may well be right if it gets to the stage of litigation, but one obviously hopes that this case, like any other case, will be settled if possible. And for that purpose, the factual situation needs, in practice, to be investigated at an early stage, so that people know what they're talking about, and so there is full disclosure to enable sensible ADR or settlement negotiations of whatever kind to take place. So one way or another, the underlying purpose and nature of that, on any view, rather suspicious-looking transaction had to be investigated. And for that purpose, I mean, your client was the person who had actually facilitated it, in the sense of doing it, albeit on the testator's instructions.
Yes.
But he it was who took at face value, or apparently, what he was told about the values and the forgiveness of the loans, chose not to make any further inquiries, and did the necessary conveyancing. I mean, all that was a time bomb for the future. And once the testator had died, and once the intention to bring a 1975 Act had been articulated, would it not then have been incumbent on him to make the inquiries on any reasonable view he should have made back in 2020?
Well, he says that he didn't have time because the issues in relation, the pressing issues in relation to the management of the farm, and the finding some way for the respondent, first respondent, and the children to get back into the farmhouse, because they were so pressing, no other matters were dealt with, and the court will be aware that matters had descended into difficulty within a month or so of the testator's death. It was clear from that point on. But what I would say in relation to the transaction is that Mr. Bowser acted for the testator on the transactions. There's no conflict there in him acting for the testator's estate and standing in the testator's own shoes once the testator has passed away. And in relation to Mr. Paul Smith, he's very clear that he never acted. Now, Mr. Paul Smith may be the person who holds the property on some kind of bare or resulting or constructive trust for the estate. But that would be a matter for the challenger to look for, because on the transaction, the testator himself could not say to his transferee, I have settled your debt by transferring these properties to you, but you hold the property on trust for me. I've settled your debt for valuable consideration, transfer these properties for valuable consideration, but you hold them on trust for me. I submit that would be quite a difficult position for the executors to hold. And of course, it is open to Ms. Smith, and likely that Ms. Smith would want to challenge the transaction on exactly that basis. But ideally, her claim would be against Mr. Paul Smith to say you are not the true legal and beneficial owner of those properties, and they should be recovered for the purposes of her 1975 Act proceedings. And the neutral executor would sit in the middle and say to the court that there was this possibility, that the value of the estate should be increased by the properties disposed of under the anti-avoidance sections in the 1975 Act.
Was it not at least incumbent on Mr. Bowser to disclose that even though his position is that he was not acting for Mr. Paul Smith, he or his firm had sent to the land registry a document which suggested that the firm was acting for Mr. Paul Smith?
I struggle to see how the testator's own solicitor, accepting instructions from the testator, could then say, but I was really acting for someone else. Or the retainer is certainly extended at the testator's direction to dealing with the registration in his father's name.
Well, as I understand it, the form sent to the land registry says that Bowsers are acting for both parties to the transaction. Now, it's your case that he was not in fact acting for Mr. Paul Smith, but nevertheless the form says that he was.
Right.
Now, and therefore, that might well be his position that he was not acting for Mr. Paul Smith, might at least be open to challenge. So should he not have disclosed that?
If matters had got that far, my reading of his evidence is that that's exactly what he would have done had the matters not, had the estate not immediately got bogged down with the running of the testator's business, which all parties accepted was probably not viable, and so that was a problematic issue, and the accommodation issue. And those having arisen immediately after the testator's death, there wasn't time to get involved with the testator's business affairs. So that's what Mr. Bowser says at paragraph 19. During the time that I was executive, the testator said I was unable to complete any investigation into his business affairs because the first respondents declared wish to have nothing to do with me or my firm. In any event, the priority immediately after the testator's death was sorting out the problem of the farm, which was probably not a viable business, and farmhouse, which was the ideal home for the first respondent and 9 of the beneficiaries. And that was in his evidence in support of the application, removal application.
Right. Is there anything else in opposition to the application?
Yes, what I then say, if I could take you back to my skeleton argument, this begins at page B62. I have set out the well-known statement of Lord Wolfe from Taylor and Lawrence at paragraph 8 of my skeleton argument. That's at page B63. And what I have said is that the application is misconceived. There was no trial and no factual evidence was relied on below. And if matters of fact are considered to be necessary before a just decision on the costs can be made, then it's the appellant's submission that this should be ordered on the appeal in accordance with ground 1, and that all the relevant evidence should now be allowed in, and not just one additional fact. I would also submit that the in dealing with the evidence at my section C of my skeleton at paragraph 11. Can I take the court to paragraph 13, where I say this? It's said to follow from the fact that, the allegation, which is denied, that the appellant acted for Paul Smith, that had the evidence of the transaction been before Mrs. Justice Bacon, it would have had a bearing on her costs decision, and that's not been proved. And Mr. Paul Smith has confirmed, apparently, that the transfer was to repay loans, and for unspecified reasons that's not really accepted by either respondent. Then I deal with the executor's duty, my paragraph 16. The transaction was freely entered into by the testator, and if it's open to challenge, that challenge should be brought by the first respondent in her personal capacity. I object to the use of the word disingenuous for the abusive adjective used of Mr. Bowser. And I deal with the conveyancer's duty, which I believe my Lord Justice Mayles has raised with me here. And I have referred to the precise scope of the retainer being a matter that this court can't decide. Now, this court, in my respectful submission, first principles is conducting a review, not a review, a rehearing. And if this evidence is in, and the court is going to make findings of fact in relation to it, which in my submission it has to do in order to say this would have influenced Mrs. Justice Bacon, it has to accept it as true, which is one of the Ladd and Marshall principles, which Mr. Hicks and I both referred to. This court then has to look at the facts, look at the contested evidence, and make a finding. And I say in my respectful submission, that's not the function of a court conducting a review of the decisions made below, rather than it would in effect be not just a rehearing, but a hearing on additional factual evidence. I also say that the substance of it is that if the first responder is correct, then Mr. Bowser should have stood down, and the court will be aware, having seen the appeal and the skeleton in support of it, that there was no means for him to step down having intermeddled, and that applied to both parties. So the reason,
if he'd expressed the willingness to step down,
Yes.
then a consent order could have been placed before the court and would have been a very simple matter to get approved, wouldn't it?
it might have been had the first respondent put forward the name of Mr. Green, which of course she hadn't.
Yeah, but I mean, this is a matter of machinery. I mean, if both the existing executors agree that they should stand down in favour of an independent third party,
Yes.
then with a little bit of common sense and assistance with the procedure, that shouldn't be a difficult exercise to bring about, not least because it is so glaringly obvious that in this particular case, that was the right thing to do in order, I mean, because of reasons we'll probably come on to on the main appeal. But
Yes. But the issue here on the application is whether this material should be before the court on the basis that it would have had a major bearing on Mrs. Justice Bacon's decision. And I say that if that decision had been made, taking into account the information which is now known and which it said should have been before her, then that would have been a further unproven fact which she would have taken into account, and I would say that was also unfair to a professional man. To say to him that on the basis of contested evidence as to whether he had acted for Mr. Paul Smith and the extent to which he had acted to Mr. Paul Smith and the extent of his duty as personal representative arising out of that, to make a decision that he should be condemned in costs, I say would have been an additional ground of unfairness. So if it would have had a bearing on her decision, it would simply have strengthened and reinforced the grounds of appeal, and not necessarily the fairness or otherwise of the decision to make him pay the responder's costs and not receive any indemnity in respect of them. My lords, I don't think I can take my opposition to the application any further unless there's something that the court would like me to deal with which arises out of the main appeal.
All right. Well, thank you very much. Mr. Green, do you have any interest in this application one way or the other?
My lord, I'm neutral on the application.
Very good. All right, we'll rise.
Oh,
So
I thought we might discuss and see what we want to hear.
All right.
stick on your back and say,
Right. It seems to us from the arguments we've heard so far that the application is to some extent interlinked with the issues arising on the appeal, and therefore rather than hear Mr Hicks in reply and make a ruling, we think that the best course is to allow Ms Taylor to open her appeal, to deal any further in the course of her submissions if she wishes to with the new material, and then for Mr Hicks to make his submissions, including what he would have wished to say in reply on the application, and we will, in all probability, deal with it compendiously in our judgment and make our ruling in the course of that. Is that sufficiently clear?
My Lord, I'm very grateful.
Very good.
Lord, if I can then take the court to the, if I call it that, the main appeal. This is by an appellant's notice, which is at A1 in the core bundle.
Yes.
And it appeals against the order made, which the court will find at A70, but I'll come to that in a moment. The relief sought by the application notice is the setting aside or varying of the order made. On page A4, the summary is given of the order made, that the appellant was to pay the first respondent's costs of the claim, to be subject to a detailed assessment on standard basis if not agreed, should not be entitled to any indemnity in respect of his costs of the claim from the estate, and if and to the extent not otherwise paid by the claimant, the first respondent should have her costs of the claim out of the estate to ensure she had her full indemnity, and in order that the appellant was to pay the first respondent a substantial sum on account. At page A6...
That payment on account's been made, has it?
Yes. As I understand it, the matter... I understand it, the entire...
The costs
have been paid.
Good.
The relief sought is set out in summary at page A6. Either to set aside the order or to vary it. The primary submission is that, as made at the hearing before Mrs Justice Bacon, before the cost submissions went in, that the normal order would have been for all parties to have their costs out of the estate, and in my submission that was the appropriate order, and so I invite this court to consider that. I did identify one or two possible heads of costs which shouldn't be met out of the estate, particularly those relating to the pre-claim steps being taken by the first respondent in relation to her 1975 Act claim. Costs in those matters follow the events; they don't come out of the estate unless by agreement. And it was clear, I said, that some of her correspondence and so on related to the 1975 Act claim rather than the administration of the estate.
But aren't those matters for the detailed assessment?
Um,
I mean, they're not. They don't go to the question of principle, do they? I mean, the orders for costs were made in relation to the costs of and incidental to the application and the claim, presumably.
Yes.
And then it's a matter for the whoever does the detailed assessment
To
if
fill
the
it out,
costs
those-
can't be agreed to work out whether a particular item of correspondence comes within or outside those headings.
Then I can pass on very swiftly from there. I'm grateful, my lord. And then there was a possibility of a percentage issue and a possibility of remitting the order to the High Court, remitting the matter to the High Court for an order to be made after a hearing. And I have stressed in all my writing that is the least desirable option. Not least because if evidence is to be led, dealing with the conduct issues, and they were very much in the mind of Mrs. Justice Bacon, they are bitterly contested, and the professional executor has not said very much on those issues because they're bitterly contested between the first respondent and the testator's family, and the things he's been aware of that he hasn't wanted to say, and there are things he's not been aware of which he knows the family would like to say, which he considered to be unhelpful, and that's apparent from his witness statement in support of the application and also from his cost submissions. Has the court been able to read through the decision of Mrs. Justice Bacon? Should I take that as read?
Oh, absolutely, yes.
I'm very grateful. And then I come then to my grounds of appeal, which are at page A12.
These are rather spacious grounds, if I may say so. I mean, normally one expects the grounds of appeal to be fairly concisely formulated. But,
Are they too lengthy?
well, it's perhaps a matter of taste, but this almost reads like a skeleton argument.
Oh, I
But
see.
anyway, that's all
Yes,
right.
I see. Oh, well, I'm very grateful for the hint. There's always scope for improvement in the way one presents cases. Should I take it then also that the court's fully familiar with my grounds of appeal? Then I won't.
Oh, yes, you can take it that we've read the material.
Yes,
And
great.
go straight to your submission.
Right. Okay. Then dealing then with my should I not? Then the court doesn't wish to be taken through my skeleton arguments.
No, there's no point in repeating it. By all means, highlight points
Yes.
or focus things you particularly want to raise, but
Yes.
you don't need to read it out.
I'm grateful. I did put in a brief chronology with the skeleton argument and a more expanded one, which the courts will find at page A62 to 66. I'm not sure whether my friend's respondent's chronology has reached the court. That's an even longer document, but I would very much hope that the key elements are all stated within the chronology. And the issue in relation to the I think it'd probably be better if I went back to the judgment, which is at A70, and looked at the reasons given by Mrs. Justice Bacon for making the adverse cost order, which she did.
Yes.
Looking first at her paragraph 1, that there was no proper pre-action correspondence and there was no protection of a Beddoe order. I have dealt with that in my proceedings. It's true there was no Beddoe order, but that only offers cost protection, and as Mr. Hicks has suggested in his more recent skeleton on his application, his Ladden Marshall application, there could be circumstances in which even with a Beddoe order you may not get protection. The court would look at the substance of the matter. And what I say is the issue is really whether the costs were properly incurred, and if they were properly incurred, as indicated in Bonham, Blake, Lapthorne, Linnell, if those costs were properly incurred, then there is no reason why the person representative or other fiduciary should be at risk if those proceedings were properly incurred. And what I say in this case is that these proceedings were necessary the proceeding, the administration of the estate had ground to a halt. It was in a state of standstill and deadlock. There were two executors, each acting from the will, acting unilaterally, not consulting with each other, for reasons which couldn't be thrashed out before Mrs. Justice Bacon, and were probably not appropriate to be. But in those circumstances, I say, she couldn't, in effect, make a decision putting the blame on one party rather than the other. The problem probably lies in the appointment of the testator's own solicitor and his divorcing wife in the circumstances of a very acrimonious divorce. He was only in his 40s, and he may well have anticipated that the divorce would be past history by the time the will came into effect. But nevertheless, that's probably where the problem stems from, that it was never going to be an effective way of working, whilst the widow was in the middle of the acrimonious and financially. And that was why Mr. Bowser sent his letter of the 7th of June, which in my submission is appropriate for a professional executor to send in the circumstances, suggesting in a very neutral, in my submission way, that rather than acting as an executor, Mrs. Smith might want to take legal advice about her position in relation to bringing 1975 Act proceedings. Now, it's said against him that from the outset he didn't want her to be an executor, but with respect to her, that isn't the case, and he's not the enemy. He's unfortunately caught in a crossfire. But he quite this is it's at page B127, my lords and ladies. At B127.
Sorry, could you say? I'm sorry.
That's in the supplemental bundle.
Very confusing, having all these different bundles over that. B127.
Indeed.
What? Sorry, my B doesn't go as far as 127. This is the new bundle you're talking about.
No, this is the appeal supplementary bundle.
Oh, you mean the original supplemental bundle? Right,
Yes.
sorry.
I'm going back to the main appeal. So
Yes.
I'm hoping to make my submissions really on the documents in the core bundle and the supplementary
Okay,
bundle.
sorry, I'm with you now.
And a B127
Yes.
of the supplementary bundle, if I can
Yep.
take the court if I can invite the court first to look at the date, 7th of June, the deceased finally died after his accident on the 29th of May.
Yes,
So this has been a week of his death. It's very prompt.
yes, absolutely.
And the second paragraph, he says, although we are still trying to get to the bottom of all the facts, our understanding is that a decree nisi of divorce was granted some time ago. You will also see that the will makes no specific financial provision for you. We have no doubt that you're already legally represented and would respectfully suggest you take advice as soon as possible over your position. It may be the case that you wish to bring a claim under the Inheritance Act on the grounds the will fails to make reasonable financial provision for you. If you wish to make such a claim, then you may well be advised that you should renounce your position as an executor of the will. However, that is a matter upon which you must take your own independent legal advice. But then it goes on to deal with what has been the key issue for Mr. Bowser. The issue of executors is a pressing matter because Mr. Smith was, of course, engaged in a farming business at the time of his death. Arrangements need to be made by the executor or executors to open a bank account to enable the farming business to continue and for the day-to-day expenses to be met. Would you therefore please let us have your decision upon whether you wish to renounce your right to the grant of probate as soon as possible? He then goes on to say that even if she renounces, of course she'll want to know what's happening in the estate and he will keep her informed. Then there's a sensible and, in my submission, reasonable discussion about how far she wants to be involved in the funeral arrangements. And it is the case that she didn't want to go to the funeral because of the state of the relationship between her and the testator. So that was the first point at which the professional executor in my submission raised the appropriate issues and raised them in an appropriate tone. And by the following letter, B129, this is 27th of June, within 3 weeks, he discovered that far from responding to him, Ms. Smith had been taking actions in the estate and he was getting complaints from those who were in control of the farm that they were being prevented from being able to run the farm, electricity cut off, online banking suspended, and so on. Now, these facts were not tested at the hearing before Mrs. Justice Bacon, although there is some element of concession by Ms. Smith in the correspondence immediately before the hearing. If I could take the court to her solicitor's letter of 7th of October, which is at B172 in the supplementary bundle. And in particular to the paragraph 2 on page B175. And the sub-paragraphs there, where it's admitted that Julie contacted the insurance broker at sub-paragraph 1. It's admitted at sub-paragraph 2 that she notified E.ON, that's the electricity supplier to the farm, of Ian's death and sent them a copy of the will, inquired about cut-off charges and asked for the options available as she was not in a position to continue paying the electricity for the farm. Subparagraph 3, a matter which she'd already said that she'd been advised by the coroner to use the tell us once arrangements. So something had happened, and the electricity was cut off. That was a matter of dispute, but the professional executor's understanding from the family was that the electricity had been cut off. So steps had been taken in the administration of the estate, and matters had reached an absolute standstill by the time that the professional executor sought advice and issued his removal application.
Okay, so can we just pause there for a moment? And the legal position where you have 2 executors appointed under a will,
yes,
as I understand it, but please tell me if I've got this wrong, is that their appointment derives from the will.
Indeed.
There is no suggestion in this case I've seen that the will was in any way invalid.
No.
So both executors were in the saddle from the moment of the testator's unfortunate death.
Indeed.
And what's more, the entire estate had vested in them. They may not have been aware of that fact. As a matter of law, the entire estate was now vested in them.
Yes.
But before a grant of probate, which would confirm their title vis-à-vis the outside world,
Yes.
they both had power to act.
Yes.
And in relation to personal estate, they could act separately as well as together.
Yes.
So
Yes.
it's not a situation where they had to act unanimously. It's not like trustees. They're executors, each of whom has a right to play a part.
Yes.
The point being that if they want to renounce, they have to do that before
Before they act.
taking any steps which show an irrevocable intention to act
Indeed.
qua executor,
Yes.
for which the unfortunate term appears to be intermeddling, which is, I think, unfortunate because it gives an impression of misconduct.
Yes.
It's not the case at all.
But it
Well,
was-
it's the executor who is intermeddling.
But Mr. Bowser did explain that to Miss.
Well, in rather short form, but I mean,
He explained that it didn't mean wrongdoing. It was just they'd both taken steps.
They both think, which they were both prima facie entitled.
in the interest of the state.
They were both entitled to do.
Yes, but what had happened? They were entitled to do it, but they can also maladminister. And
Yeah.
what Mr. Bowser was saying was that the steps she'd taken were maladministration because they prevented the farm from operating. Now, the farm was recognised on all sides to be a problematic business. I don't know how far Mr. Bowser was aware that it was a loss-making business, but he was certainly, of the precise losses, but I'm sure he was aware that it was a loss-making business. And his evidence was to the effect that he wasn't sure how the farm could be continued. He would also have been aware of his limited powers as a person's representative to run the business of the testator. To keep it going and to sell it as a going concern is one thing, and that's the limit really of his power, unless it is a profitable business, in which case he would transfer it to the beneficiaries or for their benefit as a going concern. And the court will be aware that one of the persons running the business was a beneficiary, and also there's a certain amount of crossfire there too, because Jack, the eldest son who was running the farm, was not on good terms with Mrs. Smith.
It seems, I mean, on any view, the farm was a big problem, partly because it appears to have been for several years loss-making.
Indeed.
But also because it involved the question of what was to be done with the farmhouse.
Indeed.
Which
I was
on the,
coming
which
to that,
was,
my lord.
well, coming to that, but
Yes.
on any view, that was a very difficult question.
Indeed.
Um,
Because if the farmland itself was not profitable, possibly the only way to sell it for value would have been to sell the farmhouse. But the last thing that anyone wanted to do was sell the farmhouse because it was the appropriate accommodation for the family. It had been the family home before the parties to the marriage separated, and it was the obvious place for the first respondent to come back to, and that was again stated by Mr. Bowser to the court in his evidence in support of the claim. So there would have been
Is that what is? Do we know whether that is what Julie was asking for in the ancillary relief proceedings? I mean,
no. Mr. Bowser had no knowledge of what she'd asked for in the ancillary relief proceedings,
we have no evidence whatever about that,
no,
as far as I can see.
No, but bearing in mind that the executor had responsibility for the minors, and knowing that they were living in cramped 3-bedroom accommodation, and my understanding is that Ms. Smith is back in the family home with the children. No. Will she have gone back in? It's pending. Well,
of course, now it's a matter for Mr. Green, but I mean,
yes,
looking back to the situation
yes,
as it faced
yes,
the 2 executors
yes,
in June of last year,
yes,
I mean, on any view, it was a difficult situation.
indeed.
And your client, I think, took the view that Julie was in a position of obvious conflict
Yes,
because of her status as a potential 1975 Act claimant.
yes.
And perhaps you'll be coming on to that aspect of the matter,
Yes.
will you?
But yes,
I'll
but
say
in
no more
relation
about
to
it
the-
at this point.
But in relation to the steps that she was taking,
Yes.
it isn't. It's not said she didn't have the power to take them or the status. She was in post from the office derived from the will, but it said that the acts that she took, were adverse to the estate because immediately making it difficult for the farm to operate, so that the livestock, for example, could not be moved off the farm. That there was no electricity, so that it couldn't operate its bank account, and so on and so forth. That it lost its insurance. Those were matters which Mr. Bowser, in my submission, rightly felt were not positive for the estate, and he put in his evidence that the matter needed to be kept under review for the benefit of the beneficiaries. Now, the question then is how far the first respondent was thinking in terms of the benefit of the beneficiaries as beneficiaries, as opposed to their benefit as her children. And she never seems to have accepted that by bringing an Inheritance Act claim, she would be entitled to property which at the moment was destined for them. So going back to reason 1, which is where I began, I'm sorry I have digressed a little bit. I did not submit to Mrs. Justice Bacon that the letter of the 27th of June 2022 was a pre-action letter, and I accept that it was not expressed in those terms. My understanding, the proceedings were not in contemplation as at 27th of June 2022. Mr. Bowser considered himself to be firefighting in relation to whether the farm should be kept going, and if so, how. And aware of, obviously, that Jack was living at the farm, which would be a problem for his mother, but also that Mr. Paul Smith was living at the farm, and that Lorna Hayes, the testator's sister, was now assisting in the management of the farm. So there were difficulties at that time. But no, better protection was not sought. I say that because the proceedings were the right thing to do, because there was deadlock between the executors, each of whom was entitled to act, each of whom clearly intended to go on acting without reference to the other, to the point where the principal asset in the estate was not in the management of either of them, but was under the control of the family, which both of them thought was unsatisfactory, but neither of them was able to resolve, particularly if they were going to act unilaterally. That something needed to be done. So on that basis, the application was issued. That's at page 201.
Sorry, Right. Now, can we just look at the relief that was sought in the application? I mean, this is the application that was finally...
This was the application which came on for hearing, which was brought on for hearing.
Sorry, did the application... There was a claim form, was this used?
There was a claim form.
Right?
There was a claim form. But of course, there would have to be one.
Yes.
And that's at page A102. And Mr. Hicks repeatedly describes this as hostile litigation, but it was begun under Part 8, which is not unusual, I think, in removal claims. So certainly Nwosu, which is in the bundle, was also a Part 8 claim. And I say is in effect analogous to seeking directions where the directions are going to include removal. And that's it's clear in my respect to submission from the terms of the claim form, where the claimant claims for the defendant's removal or passing over, although it may have been too late for passing over under section 116, given that both parties are intermeddled. Confirmation as being the sole executor or alternatively be appointed administrator, and such further other relief. And in particular, I draw the court's attention to the possibility of the limited grant, which was what he then went on to apply for at page A201, the application which came on for hearing. Now, there is...
Yeah, okay, but perhaps the big point is, yes, he was asking for the removal of the defendant as
Yes.
PR, but he was also asking that he should then be left in the saddle as the sole executor.
Yes, he was. Because there was the grounds for removal are those set out in Letterstedt and Broad, which I don't think is in the bundle, but I'm sure the court's familiar with
It is in
that
the bundle,
authority.
actually.
Is it? But that's still good law that the only test for removal is the welfare of the beneficiaries, and it's also clear from the authorities that a breakdown in relations in between the executors isn't necessarily a ground for removal. So it wouldn't have followed from the fact of the breakdown of relations between these two executors that both would have been removed. It's a likelihood, it's a possibility, but the court would look at the welfare of the beneficiaries, and it would also take into account the wishes of the testator. And of course, Mr. Bowser had been the testator's solicitor on more than one retainer, as has been elaborated already. But if I could take the court to A201, this is a route that is occasionally taken where there is there's a deadlock or something that needs to be done urgently. And in my respect, it is the lowest grade of interference with the status quo that is possible. What it would have done is it would have given the Mr. Bowser a lawful basis for taking steps in relation to the farm, which neither he nor Mrs. Smith were really able to do. He wanted then to prevent her taking steps. They couldn't both go on acting or stymieing each other or bringing the estate to a standstill. So he would act, but under a limited grant, which would specify exactly what he could and couldn't do. And the box 10, which is on page A202, set out what he was seeking to do. He was clear that the application was for emergency relief, so not intended to be the permanent situation. Emergency relief to enable him, as one of the executors named in the will, to take urgent steps in the administration and to prevent the defendant, the other named executor, from continuing to act unilaterally and contrary to the interests of the beneficiaries. So it wasn't just that she was acting unilaterally, accepted that she had power to do that, but he said the steps she's taking are not for the benefit of the beneficiaries. And he explains that the background is the claim for removal or passing over, and it's supported. Now, Mrs. Justice Bacon took exception to the witness statements from the members of the family, but in my respectful submission, that wasn't appropriate. Jackie and Smith as a beneficiary, it was appropriate to hear from him. And secondly, neither executor was able to manage this farm. Neither was in charge. Neither could give directions. Neither could take control. So it was important in my submission for the court to hear from those people who were de facto running the farm, notwithstanding that was the situation that both the executors considered to be highly unsatisfactory. Mr. Bowser, because he didn't think they should be in charge, he thought it should be the estate, and Mrs. Smith because they were her husband's relatives, and she felt that they were ganging up against her. So the relief sought, my friend says that this is hostile. I submit again that it's not. It's really a professional executor finding a mechanism to come to court and get the matter resolved. And that's why I say the matters were properly incurred, so that even without the protection of rebedo, it was appropriate to bring a claim. I would also submit this, that my Lord, Lord Justice Henderson has said that these are matters where executors get together and have a discussion and agree a way forward on paper and don't incur great expense. And that was exactly what he sought to do, but obviously he needed a mechanism for doing that. So he brought his application and invited Mrs. Smith to consent. Now she indicated in her...
So the problem with that is once you begin bringing applications and issuing claim forms,
yes,
that's, most people regard that as something you should only do as a last resort,
yes,
in a situation where normally one hopes that a civilised discussion will enable the way forward to be thrashed out by agreement.
yes, but where it's clear that the two executors cannot reach agreement...
Well, was it so clear that it had irretrievably broken down? I mean, all we know is these heavily disputed allegations about the electricity supply at the farm and one or two other matters. We're in no position to form a view any more than the judge was about the rights and wrongs of those cross-accusations.
No, but there was also the fact that Mrs. Smith had been advised not to speak to Mr. Bowser. Her evidence was that he'd been abusive and aggressive, so she didn't want to speak to him. But it's perfectly clear that they were not speaking. The court isn't in a position to determine whose version is correct. And when Miss Stevenson came onto the scene at Ashton's, her solution was that Mrs. Smith should communicate via Ashton's, and Mr. Bowser was rightly concerned about that submission because of the costs. So there would be his costs as a professional executor, and then there would be higher costs even from Ashton's, who have a higher charging out rate. So every letter, every communication would come with a price tag.
All right. Another aspect, I don't know if you're going to say anything about this, but another aspect of the background is the question of the funeral arrangements.
Of the funeral
arrangement.
Yes.
And for the case of it, that was a matter for the two executors to decide on jointly, whereas your client took what might be thought to be a rather high-handed view, that it was really for him to make a decision and just inform Julie what he'd done unilaterally.
Well,
I mean, on any view, that was not an appropriate way to proceed, was it?
no, the difficulty there was, again, as I've said, that he was caught in the crossfire because, of course, the family blamed Julie for the death.
Well, all right. If
and unless the court wishes to hear the details of that, which he hasn't put before the court,
no.
It's just mentioned in passing in the cost submissions.
One can see perhaps how Julie perceived it as being rather hostile when her own views were being brushed off.
Yes, but she'd also made it clear she didn't want to have anything to do with the funeral.
That's a separate point.
Yes,
That's
because of the divorce.
Well, she didn't want to turn up at the funeral,
No, she certainly didn't want to.
but she did want her husband to be buried, because that was what. We have no reason to doubt he had often said that was his own wish.
Well, his family was saying something different.
Well, I know it's a type of familiar problem which often arises, and ultimately it has to be brought before the court to resolve. But the point is,
But he couldn't. With respect to that, my lord, there certainly wasn't time to do that because there were concerns about the body decomposing, and they were told to get on with it. And the funeral directors would not speak to Mrs. Smith, so something had to be done. And in my submission, it isn't fair to put the responsibility or blame on the professional executor for resolving a situation which needed to be resolved. There certainly wasn't time to come to court and get that resolved. And the funeral directors weren't going to speak to Mrs. Smith for whatever reason.
And I can see some force in the point that one way or another this was a kind of fraught family situation where nothing was going to get sorted out until the matter was placed before a judge.
Indeed.
And indeed that is what happened. The second a hearing did take place before a judge, you managed to reach sensible agreement on the order that should be made.
Yes.
And then it's just so sad it took such a long time for that result to be achieved.
Well, partly that was because when the matter got into the hands of Ashton's, they were much more focused on other issues, and indeed said to didn't agree with the proceedings. Thought the proceedings should be the application should not be pursued. Thought that the matter should be listed for a first part 8 hearing, which of course would have taken even longer to come on. And because they considered that any deadlock had been resolved by them acting for Mrs. Smith, and that's in the.
But surely the point is that the proposal which was eventually agreed was what Julie had proposed in or earlier than her statement of 8th of September, and if which was, as was eventually agreed, the obviously sensible solution. And all or a very large part of these costs would have been completely avoided if your client had acknowledged that at the time. But he pressed on, insisting on being the sole executor.
Well, that's not true, my lord. He did say that he did ask her if she would like a second trustee to be appointed to act with him, particularly because, having in mind the ages of the.
Yes, but that's different.
Yes, but he wanted to stay.
So he wanted to stay, but
Yes.
have somebody else. Well, that's not what was agreed. And what was agreed was precisely what she had proposed, wasn't
Yes.
it?
But what I was dealing with was your lordship's point that he'd insisted on remaining a sole executor, and that isn't the case.
Well, he insisted on remaining as executor.
As executor, indeed, but with somebody in post who would be acceptable to Mrs. Smith, and that person need not have been a lawyer. That person could have been somebody who was acceptable to her, but wouldn't have been acting as he thought in ways that were against the interests of the beneficiaries, and not seeking to recover from the estate property which was currently destined for them. So he did ask her, and again that wasn't responded to. And to the extent that ADR and other methods of informal settlement are favoured, obviously for good reason in cases of all kinds, but particularly cases like this where there's a bitter family dispute in the background. In my submission, it is appropriate to take into account that he did come up with a solution which could have worked if she had, instead of been using expensive solicitors, which would really run on costs for the estate on the administration system, as well as the 1975 Act, had come up with the identity of a person. And I would also respectfully submit this, that Mr. Green's name was not put forward as a suitable personal representative. That arose at court. Had it been put forward before, and had it been clear that he was willing to act and so on, then this could have been dealt with on paper. But it didn't happen until we were at court, having begun opening the application. And it was at that point that his name was put forward. And in fact, the name that Mr. Hicks suggested to the court was an unsuitable third party. It wasn't persisted with, but that was the person that he put forward to Mrs. Justice Bacon, a solicitor with whom he's had previous dealings, who takes over as a substitute personal representative and is based in Reigate. So there wasn't a specific proposal for a specific person proposed for Mr. Bowser to agree to.
But once you agree the principle, we'll both step down and find somebody independent.
Yes.
It shouldn't be too difficult to find somebody, should it? And in fact, it wasn't once that proposal was agreed.
As soon as the judge indicated that he should go, which of course he wasn't free to agree because he was in post, but as soon as the judge indicated that he could go, he did agree to go, and we were able to thrash something out at court and reach an arrangement. And in my respectful submission, that wouldn't have happened had we not been at court, because there'd been a lot of correspondence saying we're not going to engage with the removal proceedings. We want to deal with the disclosure, the finding out what's happened with the estate. The court needs to be taken to that correspondence. That correspondence begins when Ashtons were first instructed. So there's a long letter at B151 of the supplemental bundle. That deals with all the concerns that Julie had raised on first interview with her solicitors.
But I think you did say, as I understand it, that Mr. Bowser agreed to go once the judge had indicated that that was the appropriate course.
Indeed, because of course he's as the executor, he's representing minors who couldn't consent to his stepping down, and the one beneficiary he had consulted, who was Jack, wanted him to stay. So he would have been in difficulties in my respectful submission, saying, "Well, I'm going to walk out on my job regardless of what Jack wants, and regardless of the fact that I haven't been able to consult the other 9 beneficiaries, and 8 of them are minors in any event, and I'm going to walk away from my post." He might have been as open to criticism for doing that as for seeking to stay in post, as the test.
Well, it wasn't a question of walking away, was it? Because a court order would be needed.
Indeed.
But what could and should have happened, in the judge's view,
Yes.
was that a consent order was put before her, in which they would both be removed and an independent person would be appointed, and that would have avoided
Yes.
almost all of what, relative to the size of this estate,
Yes.
are quite significant costs being incurred.
Well, the removal was simply not an issue for Mrs. Smith. If I can take the court to the first real letter sent from Ashton's, the letter of the 5th of October was simply an exploratory letter indicating that they were now instructed. Their first real letter is at page B172.
Sorry, that's not correct. This is a very... She's going to take the point of it. Don't dismiss it.
Could I take the court then to page B172?
Yes.
And the paragraph to which I particularly draw the court's attention is on page B173. It's the second full paragraph, beginning, "Perhaps it would be helpful." The sentence that I would like to read to the court begins, "Plainly, 1975 Act proceedings." Plainly, 1970 Act proceedings are going to have to be issued, but it does not follow that resolution will only be issued upon the issue of that claim, and particularly not upon a final contested hearing. It is, of course, open to the parties to agree to allow Julie and the children to move back to the house now that they can begin to rebuild their lives in familiar surroundings, because that was something that Mr. Bowser put in evidence, saying that he thought that was the appropriate way forward. This should be our focus, not the proceedings, which are currently before the court, which were issued 2 months ago as an urgent application, which quite obviously are nothing of the sort. So the focus was not to be dealing with the representation to the estate. The focus was to be other practical matters where arguably the executors could act together, but arguably not, particularly in relation to the 75 Act proceedings and the occupation of the farmhouse. It is my submission that the removal proceedings, which achieved the outcome which was desired, in fact ultimately desired on both sides, was something which Julie was determined not to bring to fruition. And had Mr. Bowser not grasped the nettle, matters would have continued. They would have continued at great cost. It wasn't being suggested here that a replacement should be found, but that the removal issue should be parked.
I'm sorry, that's just not true. The final paragraph.
My friend has asked me to read the last paragraph, which is on page B177, and certainly the potential, certainly accept that the potential costs are all highly prejudicial to the estate. Accordingly, we'd welcome discussions to see how the litigation can best be settled in a matter which will be in the best interest of both parties, and more importantly, the beneficiaries of the estate. They were looking for discussion, but otherwise the matter was to be parked, and the focus was to be, for example, the matter stated, as I've read at page B173. So the parties weren't in agreement as to bringing the removal issue to the fore, but of course this was something that Mr. Bowser had identified as early as 7th of June, the letter I took the court to at B127, where he said the issue of executives is a pressing matter because Mr. Smith was of course engaged in a farming business at the time of his death, and that was still being run in a problematic way, possibly being run at a loss, certainly being run by family members to whom Mrs. Smith objected. She was on bad terms with her son Jack, and she really objected to Mr. Paul Smith and to her sister-in-law running that business. So I would submit that it was appropriate to issue the proceedings and to bring them before the court quickly. It is unfortunate that there wasn't a settlement before the hearing, but I say that Mr. Bowser can't be held responsible for that when names hadn't been put forward to him. And there'd been no response to his suggestion that Mrs. Smith nominate a third party who could be appointed to act in her place, but would be able to act with Mr. Bowser rather than pulling in a different direction from him in ways that he said were not in the interest of the beneficiaries. And all parties certainly were minded that Julie should go and live back in the farmhouse. And that's probably something which ultimately the parties might have had to seek directions on if it had been decided to dispose of the business, and the best terms on which to do so, having regard to the land itself being arguably unprofitable, not being the best price realised, and so on and so forth. But those were matters for the future. So I say that notwithstanding that he didn't obtain better relief and protection, those proceedings were properly commenced. Had they not been commenced, the outcome which was achieved would not have been achieved, and the outcome was desirable from all parties' point of view.
Sorry, before I forget, can I just raise with you a point, perhaps I'd also like to hear what Mr. Hicks says in due course about the possibility of better relief in a case of this nature. I mean, better proceedings themselves, unless I've misremembered the position, are quite a major undertaking.
Indeed.
You have to take out a separate claim.
Yes.
You have to have separate representation for the minors, who would have therefore had to have a litigation friend. And you then have to have detailed submissions on which the court is effectively able to form a view on whether this is in the interests of the beneficiaries or not.
Yes.
I mean, you're running up thousands of pounds worth of costs just to get this off the ground,
Indeed.
aren't you?
Yes. So
I mean,
that's why
it seems to me, frankly, it's sort of highly unrealistic. At least my provisional view is that's a really unrealistic sort of view to form in a case of this nature, a family case of this nature. What's really needed is just for
to get
the
on
parties to get together, perhaps with their solicitors, and have a without prejudice meeting and thrash it all out.
And
unfortunately, that never happened.
Well, I'm very grateful for that indication, my lord,
Well,
because
I'm just saying, if you disagree with that analysis, please tell me I'm wrong.
I entirely agree that better relief would have been top heavy, and the submission always has been that the cost of the rebeddo wouldn't have been justified in circumstances where there really was if proceedings were to be issued, there was only really one form to do it, and that was this.
But again, what comes back to the point, proceedings should surely have been held in reserve as a last, or at least as something which had to be activated only A, as a last resort, or B, preferably once the parties had decided on a situation that both PRs were to stand down in favour of an independent third party, which has always been the glaringly obvious solution to this problem.
Well, the problem in the interim was the management of the farm.
And again, that could have been dealt with by discussion, couldn't it? Rather than both sides getting on high horses and basically trying to deal with the farm on a unilateral basis.
Well, with respect, Mr. Bowser wasn't trying to deal with it on a unilateral basis. He simply wasn't able to interfere with the status quo, which he found unsatisfactory, and which Mrs. Smith was passionately against because it was Jack and her in-laws. So Mr. Bowser wasn't able to take any steps in relation to the farm, and that was his concern, that he had the major asset in the testator's estate, which he was not in charge of. It wasn't he was making decisions, he couldn't do anything. All he could do was let the status quo continue because he had no basis on which to interfere, and he knew that interference was needed. He knew that something needed to be done about that farm, and something needed to be done about the farmhouse and the accommodation it offered. Have I misunderstood your lordship? Is your lordship saying that because rebedo relief wasn't appropriate, proceedings couldn't have been appropriate? Is that your lordship?
No, I'm sorry. I was just. It's more one of the points taken against you is one of the things that went wrong in this case was that bedo relief wasn't sought, and I'm really questioning whether that was a realistic option.
Well, I'm very grateful for
but
that support,
obviously
my
we'll hear
lord,
in due course what Mr. Hicks says about that, but I wanted to give you a chance to comment on that.
I'm grateful. And also the issue, as said in the certificate of urgency, the view was taken that the breakdown in relations wasn't something that was capable of immediate resolution. Meanwhile, there was a farm which did need immediate handling, even with matters like the moving of livestock, which I understand hasn't ceased to be a problem. But certainly something needed to be done, and in my respect for submission, it wasn't inappropriate for the professional executor to grasp the nettle and say, I'm going to commence proceedings. I would submit also that if he had, he could have, it's arguable, he could have simply issued a Part 8 claim form seeking the relief set out in the application notice. But a change of executors was obviously in the minds of everyone. This obviously wasn't a pairing that was ever going to be functional, and had arisen in very unfortunate circumstances, which was the fault of neither. But in those circumstances, in my submission, what he did was he asked for the least possible relief, and he asked for it in the least contentious way, because by issuing a Part 8 claim and setting out his position in a witness statement rather than particulars of claim, he was able to explain why it was that he understood Mrs. Smith's position, but found that he couldn't factually get on and manage the estate, as he was bound to do from the will. The next reason that Mrs. Justice Bacon gave was that the action was unsuccessful, and I say it was successful because the relief sought was granted in part. That was the removal of Mrs. Smith. Certainly, it was anticipated after her letter of the 3rd of August. It was anticipated that she would make a cross-claim to Mr. Bowser's removal, but that never emerged. The order agreed was a removal of both, and he did not offer to stand down until he got to court, but I say that was the first point at which it was reasonable for him to agree to stand down, having regard to the lawful tests and the nature of the beneficiaries, particularly the 8 minors who could not authorise him to go or confirm that they wanted him to go, whilst Jack had indicated that he wanted him to stay. With regard to paragraph 3, that the order was precisely what the defendant had proposed, but she'd not really pursued that and given details that would have enabled Mr. Bowser to be satisfied that he would be carrying out his duty to the beneficiaries if he agreed to go. And in relation to...
Well, as the judge says, she did pursue it. It was repeated in the letter of 25th October.
Yes, but yes, if I could take to that letter, that's...
B189.
Thank you. B185. But yes, but this, B185.
No, 9.
The 20th.
189.
189. So I'm grateful. Yes, the issue in relation to removal, which I think is dealt with, with your lordship referring to B190, our approach has been utterly consistent.
No, I'm referring to the second paragraph. It is disappointing.
Oh, I'm sorry. Yes. Yes, with respect to Ms. Stevenson, I think that's quite what was said in the witness statement, but certainly I would accept that it was said here. And the answer to that is that no proposal had been put forward of an individual. And I understand that both parties at the time were making investigations as to who might be a suitable substitute person or representative. Between that date and the hearing, which was about a week later, just over a week
Really?
later. No.
There's no evidence that your client was investigating that at all.
Oh.
Nothing I've seen, anyway.
No, not openly. But when Mrs. Justice Bacon sent us out, I did confirm that it was feasible because the parties had been looking into it, and that I had had discussions with Mr. Hicks on the previous day.
Yeah.
But I didn't say the names to her, but obviously there were names.
Yeah, okay.
And I had discussed the matter at the telephone with Mr. Hicks the previous day, and without prejudice context.
But your skeleton argument before the judge says that D has agreed to step down, but only if C also does so. C is reluctant to
Yes,
step
but
down.
I think there was.
gives
I
various
did also
reasons.
say inquiries were being made in that regard. Sorry, could you also just direct me to the pages?
It's your skeleton B79,
Thank you.
paragraph 3.
But I did say at page B83, at my paragraph 32 in my submission section, he further submits that the best alternative is to leave him in post and those authority rather than substituting him for third party PR, although inquiries in this regard are being made. And I don't want to give evidence, but yes, inquiries
Mr.
are being
Hicks,
made.
you must control yourself.
Sorry.
I don't want to go into what was happening off the record, but certainly on the record, on instructions, I was able to say that inquiries in that regard.
But the judge's point, I think, is that you came to court, your side came to court,
Yes.
strongly urging the course which you had proposed in the initial application, that is to say, that she should be removed
Yes.
and Mr. Bowser should remain.
But
And you give all sorts of reasons why that is so, and there's no hint of compromise until you get before the judge. And the judge's point is, well, there ought to have been.
But with respect, well, that's not the case, because in both the claim form and the application, Mr. Bowser put forward the proposal that he should have the limited grant, which would have limited what he could do pending the resolution of the question of full question of representation. And it is something which is done where there is a particular asset that needs to be administered, where the parties are at loggerheads or perhaps one is ill or abroad, and something needs to be done as a matter of urgency. And the limited grant enables that to happen. Now, in fact, that with respect to being conciliatory or looking for solutions, that is appropriate in my submission, because normally the grant would be applied for in the non-contentious jurisdiction. So what he wanted to do is to make sure that the court understood what he was doing and gave proper directions that it was acceptable for him to do it, rather than perhaps, as sometimes happens, a party named as executor doing that behind the backs of other executors, where there's a dispute of some kind. But to come to court and say, well, at least let me have a lawful basis on which to administer the farm. Not all the other things, and then we'll go to court and deal with the removal, but for the time being at least, I'll be able to administer the farm.
Right, so that's your submission then on the judge's reasoning.
Yes.
Where do we go after that?
Right, if I can take the court back to my skeleton argument, which is at A21. I'm sorry, there was just the, I think it's at A17. Yes, I think I had dealt with this, that the judge, apparent reason, her second reason was that the claim was unsuccessful. And that's dealt with at ground 3 of my appeal, my skeleton argument on page A30. And I deal there with the fact that I say that the appellant did succeed, and that the respondents, paragraph 35, if I could take the court's attention to that on page A30, if the respondent had even gone as far as providing the 3 names informally, she might have been able to claim success in the proceedings. In the event, however, the only reason the appellant was removed and Mr. Green was appointed was that the appellant consented, having had an indication from the judge it would be appropriate for him to step down. Prior to this, his duty to the beneficiaries, including 8 minors who could not consent, would or might have placed him in breach of duty if he sought to step down informally. Such renunciation would in any event have been of no legal effect, since he had intermeddled. And I won't take the court, I think just in the discussion that we've just had, I've taken the court, in fact, through the Kershaw and Micklethwaite point about friction not being necessarily a ground for removal, and Nwosu and Nwosu, which I've also referred the court to, paragraphs 29 to 39, the circumstances in which friction will justify removal and circumstances in which it won't. And of course, the court, both below and here, would need to give due weight to the testator's clear wishes. Now, the state of relations between the testator and the first respondent meant that that was always going to be contentious. And as I say, Mr. Bowser had to make a choice, really, whether to do what the testator had asked him to do and be there for the minor children, or to step down. And he did, but in my respectful submission, he couldn't do until the judge had indicated that it would be appropriate. Ground 4 is conduct amounting to misconduct. And this is crucial because it is possible for a personal representative to be ordered to pay the cost of another party, but then not to be deprived of his indemnity. And that's a position which this court could say would be appropriate for Mr. Bowser. If the court satisfied the proceedings shouldn't have been brought, or they were brought hastily, then the court could say, nevertheless, you should have your indemnity out of the estate. I've just addressed the issue of bringing and pursuing the removal claim. There was no alternative, although I accept what the court says in relation to it being hasty, but then I say it's because an injunctive relief was needed and the lowest possible form of intervention was sought by Mr. Bowser in seeking a limited grant. And that in itself, in my respectful submission, acknowledges that he may not ever get the full grant. Correspondence prior, I've accepted that there's no letter of claim, but there was considerable correspondence from 27th of June onwards. And on the 3rd of August, when the first respondent had threatened a removal claim against him, saying he wasn't the right person at Bowser's to be the personal representative, and he'd replied to that in full on the 9th of August. The court will find that letter at B133 and B134. At 45, at the bottom of that page, I do submit that the nature of the relief sought offers some justification for why the matter wasn't dealt with in the normal ACTAPS way, although ACTAPS isn't prescribed, it is frequently observed, and it's unusual for it not to be observed by persons involved in contentious probate. I would also say that there is an aspect of this which is simply an executor seeking to get practical steps taken so that the estate can be administered, and in that sense not contentious. And I think I have dealt with my paragraph 48 of how, even on an issue where they agreed, such as the undesirability of the Smith family running the farm, they still weren't able to act together. With regard to the conflict of interest, I've taken the court to the letter of the 7th of June, where it was set out, I think, in probably the most neutral and most appropriate way. Matters got more complicated as time went on, but that was probably the simplest and clearest way of stating the difficulty. And of course, it would have enabled Mrs. Smith to step down at an early stage. She doesn't seem to have accepted the invitation to get independent legal advice about her position. But what I say is this: the issue that my friend raised, in which the judge accepted, was whether somebody can be an executor, remain an executor, whilst bringing a 1975 Act claim. And what I say is that the real issue is that there is a conflict, because at the end of the day, if the claimant is successful, she will be receiving property which at present was destined for the children. So she would be taking their inheritance from them. And then it's in the nature of Inheritance Acts proceedings that they are in interference with the will. Now, it's very unfortunate that the testator died when he did, right in the middle of the financial remedy proceedings, and it is quite likely that with the divorce cross-state, she would certainly in those proceedings have received something, and she might have received half. It's certainly likely that that would be replicated in any 1975 Act proceedings, such that it was probably clear from the outset that the children would lose something.
Well, you say the children would lose, but she's looking after them, so
Yes.
what goes to her? It's not as if she's sort of salting away bags of gold somewhere.
No.
This is
No,
money which she needs to look after. Is it 9 minor children?
Yeah, 8 minor children.
8.
But it's not suggested that she wouldn't use it for the children. That's not suggested. But the point is, at
So
the end,
it's
she
not
would,
really taking money away from them.
but she would own property which they would not necessarily come to own in the way that the testator had intended.
Yes, but the whole will was, evidently drafted on the assumption that the situation vis-à-vis Julie would have been sorted out before he died. After all, he died
Yes, he
prematurely.
Yes, he didn't expect to die within a couple of years of making the will.
But it's really only on that footing that leaving the entire estate to the children without any mention of his wife makes any sense at all.
Yes.
So, to that extent, the will plainly was, so to speak, couldn't take effect in the way the testator must sensibly have intended it.
Yes.
Because he was envisaging a world where Julie's claim had been sorted out, done and dusted, long before his own death.
Yes.
But in the absence of that natural assumption coming to pass,
Yes.
there's a limit to how far you can pray and aid the provisions of the will as somehow representing a status quo which shouldn't be interfered with.
No, not that it shouldn't be interfered with, but that it would necessarily have to be if she was successful in her claim, as was likely.
But any Inheritance Act claim is it's going to be at the expense of one or other of the existing beneficiaries if it succeeds at all. And that's just a statement of the obvious.
Yes. And of course, she's under no obligation to use any property that she obtains for the benefit of the persons benefited under the will.
All the books appear to be agreed that there is no conflict of interest in any objectionable sense.
Yes.
If her PR is also a claimant under the 1975 Act. It doesn't automatically follow that those two roles are incompatible.
No, but I think that was conceded. But the issue was always, and I think it's clear from Mr. Bounce's first letter, which I say is probably the best of the letters, that it's the issue of it's often the case, I'm afraid.
Parenthesis, I agree with that. It's a pity that the tone of the first letter didn't carry through a little longer.
But I think what happened was the unilateral acts, which he felt were not in the interest of the beneficiaries.
On that scope of professional executive.
Which are not on the record because she acted, whereas all of his actions are on the record because he kept a note or wrote a letter. But that was really the issue, and I have raised a question as to how far the textbook authors are correct, and also highlighted Andrew Francis's point that it's easy for it to become a situation of conflict.
Yes.
So even though that on paper there may not be a conflict, it's easy for the parties to conduct themselves in such a way that a conflict does arise. And I say that had happened already between the 7th and the 27th of June, when at the very outset, when Mrs. Smith started acting as executor in ways that Mr. Bowser felt were not in the interests of the beneficiaries. And I would invite the court to conclude that it can't really have been in the interests. Even if the farming business was not viable, it could not have been in its interests to be hampered in any way. Now, it may be a business which needed to be sold. It may be a business which they had to wind up what they were doing and sell it, or sell it as a going concern. But it cannot have been in the interests of the estate for the farm to be hampered in the way that it ran. And there's very clear evidence from the Smith family that that was what was happening. And that when they lost their banking, it certainly wasn't one of them who rang up and freely closed the bank account.
But one might say on the other side that the bank needs to be informed of someone's death.
Of course, the bank needs to be informed, but then one would expect either the account to be transferred into the name of the executor, or for the executor to open up a new bank account so that the farm can continue, so that the business of the testator who's now died, can be continued with a view to transfer to the beneficiaries if it's a profitable business, or with a view to being sold as a going concern if there are good reasons for doing matters in that way. But it cannot be good for the farming business not to have a bank account, and not to have electricity, and not to have insurance.
But on any view, the deceased's bank account couldn't have just continued without any fresh steps taken by the bank, could it? I mean, normally the bank will only allow you, I think,
Yes.
right, what little personal experience I have, they'll allow you to use the deceased bank account to pay funeral expenses, but nothing else.
But nothing else. But of course, that's one thing to close the testator's bank account. It's quite another not to open another, and to enable matters to continue.
But where's the evidence that Julie prevented the new bank account being opened?
That she didn't. That all she did was close.
Well, she just informed the bank of the testator's death, and it then followed, as night follows day, his bank account was shut down. I mean, that's what happens.
Yes.
So what's wrong about that?
Well, because there was nothing in its place to enable.
Well, that's another point. I mean, then of course the two executors should have got together to set up, to agree steps for a new account to be opened, which would enable the farming business to be carried on pro tem.
Well, extrapolating from that, my lord, then it would really have been appropriate for the two executors to agree to approach the bank together.
Yes, why not?
But it was the response to, would you like to take legal advice about whether you want to act at all, and that is pressing, was simply to act. And so Mr. Bowser is waiting to see, is he to act with her jointly, or is she going to renounce, so that he could deal with the issues such as notifying the bank and opening an estate account so that the farm could continue to operate. He was deprived of those opportunities.
Well, surely these matters needed to be canvassed and discussed. Yes, expeditiously, but also allowing time for each party to, especially bearing in mind that this appalling accident of which the deceased died had happened only a week beforehand.
Yes, indeed.
So, I mean, on any view, it was a bit premature to be seeking immediate decisions at that very fraught time.
But then perhaps also equally for the lay executor to start taking steps. I mean, the professional executor clearly wanted to take steps because he knew the problem with the farming business.
Yes, but on any view, the bank had to be informed. It doesn't matter who told them.
Yes.
The sooner the better.
But informed in a way that would enable the farm to continue running.
Well, no, just informed. I mean, that's the first thing, surely, isn't it?
Well, not necessarily the business account, I would respectfully submit, because a responsible executor in my submission would have dealt with the issue of this account has to be closed because Ian has died, but the farm is still running, so we need to see how that can be done in the name of the executor. And even then, even a unilateral farming account would have been better. But immediately the business account ground to a halt, and there was no online banking available to it. So I would invite the court to accept my paragraph 61. This is Andrew Francis's Inheritance Act claims. So where he deals with the importance of not confusing the two capacities, and saying it's for the advisor to ensure that a person where the claimant or defendant can wear two hats comfortably, and that the duties of the person represented, especially during the litigation of the claim, are performed properly.
Is there any judicial authority that you're aware of on this question of conflict of interest or not?
I'm not. I'm going from basic principles.
Yes, I'm not criticising you for doing so. I just wanted, if there is any authority, I'd like to know what it is.
I'm not aware of any authority.
And the textbook
if the court feels able to make comments, even obiter may be the first case. But I would say that it depends very much on how the matter is conducted. And we said there was an issue of substance in relation to the way the matter was being conducted. That she was acting against the interests of the beneficiaries. And also perhaps seeking to have matters pursued, such as the issues of the transfer of the properties, as a 1975 Act applicant, and not with a view to, followed on from the ancillary relief mindset, and not in the interests of the beneficiaries. I very much regret not being wordier in my cost submissions in relation to the litigation friend point. because I was thinking very much in terms of how you draft a claim. So duly as claimant and as defendant, and then the beneficiaries or a representative beneficiary being another defendant. And of course, in relation to the minor beneficiaries, one would normally expect the mother, particularly where the mother's a widow, to be their litigation friend, and if she can't, it's because she would say, I have no interest adverse to those of the above named person. And that is a declaration she would not have been able to
Well,
say
plainly in this case, she couldn't have been.
Indeed.
So somebody,
So,
if and when 75 Act proceedings are actually taken, will have to be a litigation friend, but I understand that's already been dealt with.
but that's something which the learned judge took as me making a new point, whereas I was seeking to illustrate the point by reference to what would actually happen in those proceedings if issued. So she could have sued herself, but she couldn't have been represented the parties. So if she wanted to sue the estate, she could have been claimant, she could have sued the estate of which she was an executor. But in relation to the if you like, the active parties, who would have been the beneficiaries, she couldn't have represented them. And that was my illustration of a point, and I'm afraid it was taken as being a fresh point, and I just wanted to make that clear. My Lords, I've handed up now copies of the draft orders, which I put before the
Just before we go to that, looking at the judge's reasoning, which you've been working your way through, I think, but let me just check, that it follows from your submissions that in paragraph 5, she asked herself the right question,
yes,
but gave the wrong answer.
Indeed.
That's your case.
Yes, and I say that. I also say that his conduct in bringing and pursuing, the way he pursued them, was to bring an application for minimal relief.
No, I understand that. You've made that. I just wanted to clarify the nature of your criticism of paragraph 5.
Yes. And I don't really have any objection to the defendant as executor recovering her costs from the estate, subject to the point I made, which Mr. Justice Henderson says is a matter for the costs judge. In fact, the position adopted by Mr. Bowser at the hearing was that on what was known, including what could not be determined, the only appropriate order was both parties to have their costs out of the estate. And I say, if this court can obviously take a different view, it's in possession of as many facts and matters as the judge below. And I say that if this court took the view that Mr. Bowser should have his indemnity, notwithstanding that he was liable to pay the claimant's costs, that is also an order that the court could make. And I dealt with that in Blades and Isaac, which I say it's not clear that the judge paid any great heed to that. The reasons don't state what she looked at, so it's not clear that she did take on board the points stated in Blades and Isaac, and I would invite the court to look at those.
Your skeleton would say 33.
Yes, it's if the court has the. Does the court not have the combined authorities electronically? Sorry.
Well, we may have
got it.
We may have got it at some point, but I'm afraid I'm always a paper addict when it comes to authorities. So
Anyway, it's tab 8 of the authorities.
Tab 8.
Only one, I'm afraid.
Thank you.
I don't know if the clerk has maybe copied.
No, we've got the
We've got
authorities.
them, yes.
We've got them in
Yes,
paper
yes.
form, so it's no problem.
Okay, and it's
I mean, this is a decision of a master, Master Matthews, as he then was.
yes, and it's the passage. It's paragraph 116, beginning on page 91.
Sorry, paragraph or page?
Page 91, my lord, beginning at paragraph 116.
Thank you.
Would the court like me to read that? It's through to paragraph 124.
Well, perhaps if we read that to ourselves, it will be quicker.
And all this is very specific to the facts of that particular case, isn't it? And I'm not sure that it really helps us on the point of principle.
Right.
On the point of principle, one has to bear in mind that the learned master's approach in this case was, I think, perhaps rather questioned by the decision of this court in Price and Saundry.
Yes. I was going to take you then to page to Price and Saundry, which is next in the bundle.
Yeah.
And paragraph 24, which is at page 101. And this is Lady Justice Aspin.
Yes. I mean, the point was, one really needs to start with section 31 of the Trustee Act,
Yes. And,
rather than with the practice direction.
yeah. And then, if I could take the court to paragraph 29. All of this discussion brings one back to the question of whether the costs incurred by trustees in defending an action or arguing a point in the particular circumstances or expenses properly incurred and acting on behalf of the trust. It seems to me that properly incurred to be interpreted as not improperly incurred.
Yep.
That was the way in which Lord Justice Lindley approached trustee indemnity in the cases there cited. I have also, in my skeleton argument, this is at page A25, cited Dunbabin and Smith and Mitchell Moore's Trust Corporation, Muscle and Patience, and I would. Does the court wish to be taken to those now? I don't wish to take too long when I.
Well, we've got the references.
You've got the references, so if the court's happy with those, then I would simply ask the court to read those. But what I say is that at all times Mr. Bowser was seeking to act in the interest of the beneficiaries, particularly the minors for whom he was responsible, and in the interest of Jack, for whom he did have a very clear direction and instructions. In relation to Jack, he wasn't minded to do what Jack said, but he had to bear in mind that Jack was running the farm, wanted to continue running the farm, and so it was possible for that business to be kept going as a going concern, pending decisions being made. And his evidence before Mrs. Justice Bacon was that he'd also consulted Mrs. Hayes, the testator's sister, who was doing the bookkeeping, was minded to ask her to produce a business plan so it could be determined whether there was any future for the business. And in those circumstances, he wasn't acting in his own interest. He was clearly thinking about what was in the best interest of the estate. He was also thinking about what was in the interest of the beneficiaries and the reoccupation of the former family home, rather than the cramped three-bedroom accommodation where the first respondent found herself. And those were issues that he was seeking to resolve. He wasn't seeking anything for himself or anything which would be regarded as a breach of trust or inappropriate. And what he asked for on the application was the least possible relief to enable him to do that. My lords and lady, I don't think I have any further submissions. I'm conscious of the time, and
All right.
hopefully wanting to get a decision today.
Yes, well, thank you very much.
Mindful of the time, I'm quite happy to start.
All right, why don't you start?
Sorry, if I pinch the lector. Makes things a little easier. My lords, my learned friend has taken you through an interesting interpretation of the history of this case, perhaps rather reflecting the case she wishes had been brought in the manner she wishes it had been brought, but unfortunately we say is far from the reality of the way in which the case in fact was advanced. This was not a case seeking the least possible intervention. This was a case seeking the most hostile intervention imaginable against my client, which was her removal, not merely after a trial, but on an interim basis, whilst Mr. Bowser took full control of the estate. Let us be absolutely clear. This was not an application based on deadlock at all. It was an application based on conflict, an alleged conflict which doesn't exist, and alleged mismanagement because of early steps taken by Julie, in particular, using, on the coroner's recommendation, the government Tell Us Once service, by which all sorts of organisations are informed of the death, banks, HMRC and so on. and was promptly told by Mr. Bowser to stop intermeddling. It is an unfortunate term, especially in this context where she was an executor.
And it does seem to be a technical term, albeit it's
Perhaps
one people, in my experience, use all that often nowadays.
Perhaps it is. There is a pejorative feel to it, but perhaps it is an inappropriate term in this situation.
It certainly sounds odd when one's talking of an executor lawfully
Yes.
appointed under a valid will to say they're intermeddling.
It's simply acting before the branch.
Yes.
That's all it is.
Well, meddling is clearly a pejorative
Yes,
term
it is.
in ordinary usage, and adding a prefix to it makes it
Yes.
sound even worse.
Yes, indeed.
It makes it sound pejorative,
Yeah.
but it's not when it doesn't necessarily carry any negative connotations.
But what actually happened in this case was then an aggressive application without any of the usual pre-action protections was advanced, but not to say to the court, look, there's a problem. We've got a deadlock. We can't break it. There's various options for resolving that. I could stand down, Julie could stand down, we could both stand down, please help. That might have been an application that could have been made, but it wasn't. The application was for Julie's removal, pursued in an extremely hostile way. And it was only when my learned friend had already opened her submissions on the basis of conflict, not on the basis of deadlock. And Mrs. Justice Bacon said, well, why shouldn't it be your client that goes? That we say, capitulated to our client's position, which was that both go. And that was her position all along. And had proper pre-action procedure been adopted, it would have been clear that that was the position all along. And all of the costs could have been avoided, save possibly for a simple consent order under a short, uncontroversial Part 8 application explaining we're in a deadlock, we've agreed to stand down, it's far better that we stand down and litigate because of the costs, and we can have an independent person come in and do the job, if indeed that was necessary at all. I do want to go back, I'm afraid, through the timeline. As we know, Ian died in tragic circumstances on the 29th of May. Now, Ian and Julie had a long relationship. It was a 20 or so year relationship. And as far as she was concerned, for all his faults, he was the love of her life. It was when the police intervened and concerns were raised for the welfare of the children that she left, fearing that they would be taken into care. The suggestion that there was acrimony it's unsurprising that there were, say, certainly high feelings running, but the idea that she hated him and didn't want to attend his funeral because of the breakdown in the relationships just isn't right. Certainly there was a polarisation between his family members and her. Jack seemed to blame her for his death. Of course, they'd been separated for several years. The circumstances of the death are that he was in he had gone on the run after a police and DEFRA raid on the farm, and was killed a few days later in a police car chase. Julie's not to blame for that, and I don't think there can be any serious suggestion that she is. It is utterly tragic. And here is Julie with 9 children, grieving children, and she is grieving herself. And that's the starting context. And the initial letter, I agree, is somewhat. It is probably the kindest letter in tone, although no doubt not particularly welcome so close after the death. But it's what Julie then describes, unfortunately, is that Mr. Bowser was aggressive, abusive, and intimidating in a telephone communication, and made it clear that he would be acting unilaterally. Now that's disputed evidence. So we don't need to go there. What we do know is what happened when the next letter comes in, which is the letter, the 27th, the letter of the 27th, which, in my submission, demonstrates an extremely aggressive and high-handed approach by Mr. Bowser in respect of the funeral. Your lordships were quite right. It wasn't his decision to take. It was a decision that had to be taken together. Julie knew Ian the best. He was a man of the land. She also represented all his children, save Jack, who wasn't living with her anymore. Their wishes and their wish to attend the funeral and their wish for their father's wishes to be upheld was simply overridden. As far as he was concerned, he was going to side with the other members of the family, the sister, Jack, as one assumes the father, who had said he wanted to be cremated. But that really wasn't his decision to take. That, in the circumstances, was an extremely aggressive and extremely unhelpful start to the relationship. But moreover, this letter asserts there's a conflict of interest in her role as executor. And
Sorry, can you give us a page number?
Oh, I'm so sorry. Yes, it's the supplemental bundle. I don't know what tab. I have a tab that says correspondence
Well, it's
on it.
B129.
It is, yes, thank you, lady. It's
You're lucky if you've got tabs.
B129. B129.
Yes, I know we looked at this before.
I don't know if your lordships have had time to actually read it and digest it.
Yes.
But essentially, it asserts that there is a conflict of interest. And she is told in no uncertain terms, do not further intermeddle in the estate. Do not do anything more, in other words. And she doesn't. So it's very hard to criticise her because the further steps that one would expect to be taken, like opening a bank account, like arranging for essentially transitioning the farm into the control of the estate, take place when she has been told in no uncertain terms, do not act. And she is told if she does, there'll be an application to court. That's quite an aggressive stance to take with a co-executor who is taking the entirely appropriate and lawful steps, using the government Tell Us Once service in particular, that means that people get informed of what's going on and starting to make those first inquiries of the various suppliers and so forth.
It's perhaps an unfortunate aspect of this case that the first letter on the 7th of June was obviously written by Mr. Bowser himself. And you can see it has his name at the top above the date.
Yes, and there's a. Well, I couldn't possibly. It's been
well, at least that's what I would infer. That seems like it. I may be wrong about that. But then, certainly, by the time we get to the letter of the 27th, this is now Bowser's acting on the instructions of Mr. Bowser, and the name of the person who probably wrote the letter is Mr. Chowdhury. And I may be wrong about that. But, so it may be that the slightly more impersonal nature of the correspondence reflects that change in the people dealing with it. But ultimately, they all emanate from Bowser's.
Yes, I don't.
On behalf.
Yeah,
it's just the. Yeah.
I don't think we have to simply assume that is the stance that was being taken, whether on direct instructions, whether Mr. Bowser had input into the specific terms of the letter.
Plainly, he must have been happy for it to go out as a
letter
representing his position.
But that is the last of the correspondence before proceedings were issued.
Yeah.
Issued was on the 2nd of August. That's it. There's no attempt to say, look, we've got off on the wrong foot. There's issues that need to be sorted out. Can we work together? And if we can't, rather than the enormous costs of hostile and contested litigation, why don't we just agree that we'll get somebody independent in at that stage? There's no correspondence to that effect. There's not even the opportunity for correspondence to that effect. He hasn't even warned her he's going to bring this application in a letter before action for her removal. He said, don't act anymore. He certainly hasn't said, I'm about to issue a claim for your removal. There's simply nothing. And in fact, what happens then is a proposal. It's at 131, continuing through the correspondence. DP Legal were the solicitors instructed in the divorce by Julie. Now, they're not chancery specialists, and I think she explained in her witness statement they were acting on a pro bono basis until she could actually get specialist representation. But they say, we are discussing, it says third paragraph down, in respect of our client's position as co-executor, we are currently in the process of discussing the options with her. However, she's very clear she is unhappy with the choice of partner in Bowser that's been appointed. And our suggestion is that it may be prudent under the circumstances for an alternative partner to be nominated in place of Brian Bowser. And it's important to note, I'm sure your lordship have seen the will, and I'll take you to it if needs be, but the will doesn't appoint Mr. Bowser by name, it appoints a partner in the firm Bowser, as is often the case. It doesn't have to be him. So here we have them saying, we're looking into this, we're discussing the position. And maybe you might want to think about a different partner. But instead of calling a halt to the proceedings at that stage and actually engaging with this process and saying, well, let's talk about this, the proceedings are served. They are served shortly after. And it's page 133 is the letter in response. He says, the third paragraph, and our person is the best placed amongst the directors of the firm to be executor of the estate, and has himself intermeddled to the extent he cannot now step down from those duties without an order of the court. For the avoidance of doubt, our client does not intend to step down as executor. And then further on, the claim to remove Julie Smith as executor. We explains that he submitted an urgent claim. A copy will be served on her, and a copy was provided not by way of service. And then he says, that's the bottom of the page, as stated above, your client has a clear and fundamental conflict of interest in acting as the executor of the estate. This conflict of interest is further highlighted by your letter in which you confirm your client will make an application under the Inheritance Act. Your client cannot continue to act as executor if she believes she has a claim against the estate and further is taking steps to pursue that claim. They go on to refer to a charge that Fraser Dorbarns were in the process of registering. I think they get the wrong end of the stick here. Fraser Dorbarns, as I understand it, had acted for Ian, the deceased, in the divorce and had some outstanding fees. I think that was the position. So it wasn't anything to do with her having incurred fees and costs, or money said to be owed to her.
No, I'd read this as referring to a third-party claim against the estate.
That's exactly what it is.
Yeah.
Yes, but it was simply that she'd been given the papers which she provided to them.
Yes.
It was nothing more than that, because it was a claim against the estate. And then they go on to say at the bottom, under the heading removal of Mr. Bowser. You've not set out any legal grounds as to why Mr. Bowser should be removed as executor of the estate. If your client intends to pursue such an action, your client is required to set out the legal basis for the same. Not being happy with Mr. Bowser being executor is not a good reason. In any event, he's intermeddled and as such is unable to accuse himself. So they're making it pretty clear that Mr. Bowser is not stepping down. This application is for Julie's removal, not because there's any question of him stepping down. Over the page, it's just maybe just easiest to go through this page by page. B136, we have the service of the claim and the application. That's the 10th of August on Julie. There's a covering letter of 30th of August regarding. Essentially, there's a hearing date that is fixed in front of that's a 139 before Deputy Master Arkush via Teams. And on the 24th of August, so the following day, Bowser's write to the court asking essentially for a more urgent hearing. And there's a certificate of vacation business at 141. So just pausing there, we've got up to the issue of essentially the issue of the claim. I think it is actually important that we see the evidence. I'm sure your lordships have read it, but given that what has been said about Mr. Bowser's stance in that litigation, I think it's important one just references the evidence. Mr. Bowser's evidence is in the core bundle. It's behind tab 11.
We don't have tabs.
Oh, I'm so sorry. It's A105. This must have bewildered you when you're reading my skeleton argument. It's A105. Here's his witness statement. And I'm sure your lordships will have read this, but just dealing with some of the salient points. And if we go to A108, paragraph 10, it's explained that Jack and the grandfather, that's Paul Smith, are running the farm. They continue to do so, and they're being helped by Lorna. And further at 12, he explains there's stock on the farm that have to be fed, milked, mucked out, and cared for, which is being dealt with by Jack, Paul, and Mrs. Hayes, the sister. However, that situation cannot go on for very long, and decisions will have to be made concerning the continued viability of the business. It's not the case that he was saying this business wasn't viable. He said it needed to be looked at. Over the page is reference at paragraph 13 to Jack having a business of as a butcher, and he has his own herd of cattle.
No, it says that the testator was keen that he should. Does that mean that he does have?
Well, in fact, what he does have is what happened.
Is it?
As explained further on, it's about 5 or 6 lines down. A room at the farmhouse was recently converted into and equipped as a butchery, and it's been apparently fully checked and approved by the local authority. And the intention was that effectively that there would be a butcher's business around there. I know that.
I'm afraid I was so engrossed by your submissions that I
lost the time.
wasn't looking at the clock.
Well, I'm pleased that my submissions have that effect, my lord.
Is that 10 past?
Yes, it is.
All right, we'll better say 10 past 2 in that case.